Today, we are diving into a legal battle that could seriously change how your own neighborhood is run. It's about one homeowner versus her powerful HOA, and it all boils down to a really simple question. In this digital age, what even is a meeting? So just imagine for a second, the committee that controls what you can do with your own home. The color you can paint it, the kind of fence you can build. What if they were making every single one of those decisions behind closed doors? That's the fear here. But the closed door, it isn't made of wood. It's a digital wall. And that's exactly what one homeowner, Amy Hilburn, suspected was going on in her Arizona community. So she did what most of us wouldn't. She took her homeowners association to court. And she sparked a case that could totally redefine transparency for HOAs everywhere.
All right, so here's how we're going to break this all down. We'll start with the complaint and the specific law at the center of all this. Then we're going to step inside the actual hearing room, take a look at the technology they were using, and then we'll get to the judge's pretty surprising decision and what it all means.
Okay, let's set the stage. The official case is Hilburn versus the Stetson Valley Owners Association. And the whole fight is over this one super powerful group called the Architectural Review Committee, or ARC. This is the team that says yes or no to things like your landscaping plans or a new patio.
Right from the very beginning, in her opening statement, Amy Hilburn made the stakes crystal clear. See, in her neighborhood, the ARC's decision is final. You can't even appeal it to the main HOA board. So with that much unchecked power, she argued, it is absolutely essential that they do their business out in the open.
Now, Hilburn didn't just show up arguing about what's fair. No, she built her entire case on a specific Arizona state law, a law that was written to guarantee transparency.
On the surface, the law seems pretty straightforward, but I want you to notice the very specific wording here. It doesn't say all meetings have to be open. It says any regularly scheduled committee meetings. And as you're about to see, those two little words, well, they create the legal loophole this whole case is going to turn on.
So with that law as the centerpiece, both sides walked into the hearing room ready to go. And really, it was a fight over the meaning of just two words, regularly scheduled.
Hilburn's argument was simple. Look, the ARC has always had regular monthly meetings. Just because they moved those discussions to an online portal doesn't change what they are. But the HOA's defense was just as direct. Nope, we don't have those meetings anymore. Since nothing is regularly scheduled, that law just doesn't apply to us.
To back up her claim, Hilburn came with receipts, a mountain of them. She had meeting minutes going back years, from 2017 to 2021, all of them talking about monthly meetings. One even specifies the first Tuesday of each month. She even found their own website calendar showing a recurring event. Her point was pretty clear. This is the textbook definition of a regularly scheduled meeting. But then, everything changed. The HOA started using this new technology, an online portal to handle all these architectural requests. And this, right here, is where things get really, really murky. This brings us to the core legal puzzle of the whole case. Can a bunch of clicks, comments, and votes inside a software program, happening whenever people feel like logging on, can that actually be considered a meeting in the eyes of the law?
So here's how the system actually worked, according to the testimony. A request comes in, and the 5 committee members get an email. They can log in whenever they want, day, night, doesn't matter, to review it, leave comments, and vote. And here's the crucial part. Everyone on the committee can see what everyone else has written. And that last point, well, that really caught the judge's attention. During the testimony, she just jumped in and asked this question right here. I mean, think about it. If members can see each other's comments and then reply, isn't that just a conversation in writing? A witness for the HOA even admitted under oath that, yeah, back and forth discussion was possible. So let's recap. You've got a clear history of regular meetings. You've got a new digital system where even the HOA admits discussion is possible. It really seems like this case is leaning hard in the homeowner's favor, right? Well, the judge's final decision is going to surprise pretty much everyone. So despite all the evidence, all the testimony about discussions, the entire verdict didn't hinge on the word meeting. It hinged on the word regularly. The judge zeroed in on the exact phrasing of that law. So what does regularly scheduled actually mean, legally speaking? Well, it has to happen at a fixed, predictable, recurring time. Think the first Tuesday of every month at 7 p.m. It's predictable. You can put it on your calendar. And that right there was the whole case.
because the ARC members could log in and vote whenever they wanted. One person on a Monday afternoon, another on Tuesday at midnight. There was no single, fixed, predictable time. The activity was happening regularly, sure, but it wasn't regularly scheduled. And so the judge had to rule based on the letter of the law. First, she found that nothing actually requires the ARC to hold regularly scheduled meetings in the first place. And since their new portal process doesn't happen at a fixed time, it just doesn't qualify. So the HOA was found to be not in violation and the whole petition was dismissed.
So, what does this all mean for the rest of us? Well, this ruling really shines a huge spotlight on a gap between laws that were written in a totally different era and the way we actually live and work today. The Arizona open meeting law, like so many others, was clearly designed with a physical room in mind, a place where people gather at a specific time on a specific day. It just was never built to handle these ongoing, whenever you want digital conversations. Which leaves us with a really critical question. This case basically revealed a giant loophole. Technology allowed this HOA to follow the letter of the law, while you could argue they were totally violating its spirit. And as more and more of our world is governed by clicks and software, you have to wonder, how many other laws out there are just one tech update away from becoming totally useless?